Hello, everyone. I'm Kathy Johnston Pittman, the Director of Professional Development with CAMS. Welcome to our monthly Ask the Experts webinar, where we offer you the opportunity to be informed by an expert in community associations. Today's webinar is recorded and will be available on the CAMS website as early as tomorrow. Today's expert is Ellen Wortman, an attorney with the Wortman Law Firm in Wilmington, who's focused her practice on community associations in the Wilmington area for the past 20 years. We've worked with Ellen many times over the years and always enjoyed the varied and interesting legal topics that arise in her practice. Ellen is a regular speaker for the CAI North Carolina events and serves on the legal roundtable for CAI North Carolina. Some crazy things Ellen has experienced that she'll discuss with us today include animals, people, and property. Welcome, Ellen, and thank you for being with us today. I'll turn it over to you.
Thank you, Kathy, and hello, everybody. I'm glad you could join. We are going to cover some varied topics this afternoon. And again, the title of the seminar is You Can't Make This Stuff Up. So if you are a board member, then you probably know this already because we get to see a varied and very wide range of issues that cross over our desks, you as board members, me as the community association attorney. And it's one of the reasons I love my job. It keeps my job very interesting. And I often tell people I have the most interesting job in the world. So let's dive in and we'll talk about some of these things. So we're going to start with animals, people, and then property. And so some of the interesting things that we deal with and questions that come across my desk or in my inbox involve Fair Housing Act issues, ADA issues, emotional support animals. Kathy and I once had an issue with a horse in a single family neighborhood, and I've dealt with pigs, I've dealt with chickens, and of course dogs and cats and bunny rabbits and everything else. But with respect to the federal laws, and these will apply both North, South Carolina, as well as any other state, there are really two main laws that you need to be aware of. There's the ADA, which is the Americans with Disabilities Act, and the FHA, which is the Fair Housing Act. Now, the questions are that I always get, well, and the ADA is something that you'll hear more commonly in everyday vernacular. People will say, well, that's not ADA compliant, or that's against the ADA. And the important thing to remember as a community association is that the ADA may not actually apply to your community. And I've got on the slide some more information about why, but in general, the ADA applies to commercial facilities. So if you are a mixed use community, you've got condominiums upstairs, you've got commercial space downstairs, the ADA would apply to your common spaces. But if you are a single family home community or a residential condominium and residential only, then chances are the ADA will not apply to you unless you rent out your common areas to the public, like you rent out your pool to a local YMCA for swim meets, or you rent out the clubhouse for local organizations, things of that nature. And so if the ADA does apply to you, the key that you need to know there is that it's usually about construction issues, and that's property, but making sure the handicap ramps, accessible building entrances, things of that nature. Modify the pool, either by having a chairlift or a gradual entry, things of that nature. But with respect to animals, the ADA really applies to service animals in particular. Now, the FHA, this next slide, the FHA, the Fair Housing Act, that will apply to every single community, regardless of whether or not you have any commercial use and whether or not you rent out your facilities. So oftentimes people will approach the board or approach the manager with an ADA request. And what we have to do is we have to treat that like an FHA request. So even if they use the wrong acronym or they refer to the wrong law, we have to treat it as a proper request under the FHA. And we have to give that animal request its due and proper treatment. So what should you do to ensure that your community is adhering to the guidelines of the FHA, which again applies to everybody? You have to make clear and non-discriminatory rules for your common areas. You have to make sure your covenants are non-discriminatory, and you have to educate yourselves as the board for the ability to, or for the homeowner's ability to seek reasonable accommodations. The best way to do that is to develop a uniform plan or guideline for when you do receive a request. Now, HUD has published a guideline for community associations where you can actually follow it step by step of the legal questions that you can ask. And HUD is the Department of Housing and Urban Development. It is a federal government entity, and they are the ones that really enforce FHA violations if there are any that have alleged to have been occurring. So that document that goes step by step through the process is very helpful. The first step in determining whether or not something is a reasonable accommodation request with respect to an animal or any other type of reasonable accommodation is to determine whether the person making the request has a disability. Now, that disability may not be visible. So this is where emotional support animals come into play. It's typically very easy to tell if somebody needs a seeing eye dog. It is not always easy to tell if somebody needs an emotional support animal. So this is where it gets more tricky. And so the reasonable accommodation is something that is an exception to a rule. So when we think about a no pets policy, for example, in a condominium, then that is a rule that we are allowed to enforce because the condominium common areas are things that the board can develop rules for. But if somebody has a disability and needs a reasonable accommodation because they need an emotional support animal, for example, we would have to allow them to have that emotional support animal, even though we have a no pets policy. Because what the Fair Housing Act would say and what HUD would say is that's not a pet. That is a different category altogether. It's an emotional support animal. And emotional support animals and service animals are also two different things. Service animals provide a specific service, i.e. seeing eye dog. Emotional support animal just provides that emotional support. So it doesn't have to be trained to do anything in particular. I even had a lawsuit one time where there was an emotional support show chicken. And the HUD lawyer, when I was pushing back on him about, of course, there being poultry and chicken restrictions specifically in the documents, said to me, well, it brings this person some calming effect by just stroking the feathers of this silky soft show chicken. And so that's how it qualified under HUD's eyes for its attorney as an emotional support animal. So it may be something that's really out of the box.
Ellen, like you mentioned, you and I dealt with a case where someone claimed they had an emotional support horse, and that was certainly unusual. Another unusual one I had was someone had an emotional support kangaroo
Oh
that
my.
they wanted to go in the pool with them. So we would routinely get calls that the kangaroo's in the pool again. So that was certainly an interesting situation as well. But this is one that people are emotional about, right?
They are on both sides of the issue. So, people who have these animals feel very strongly that it is something that they need in order to fully enjoy their property. And that, of course, is part of the law of the Fair Housing Act, that everyone deserves the ability to fully enjoy their property. And then people on the other side who don't want the emotional support animals around, or maybe don't understand why emotional support animals would be allowed to be around, feel very strongly that they should not be there, or that emotional support animals are too easy to obtain. And I think most of us have seen the websites where you can send away for a vest or something like that for an animal. And I will assure you that you are allowed to ask for medical documentation that the animal is necessary for the disability. And the law requires there to be a nexus or connection between the disability and the animal. And so the question then becomes, well, if you refuse, was it a reasonable refusal or was it unreasonable? And I put some examples in here. Some of the ones that don't involve animals, just for your information, would include things like hiring a sign language interpreter at an annual meeting for hearing impaired owners. That is a reasonable request per the law, and that should be paid for by the association. And then designating parking spaces. And this can be difficult, particularly for those of us who live in coastal communities where parking is a premium, especially in the summer. But the law would say that if people have a physical disability that requires them to need to park closer to the building, even if there are no assigned spaces for anybody else in the community, those individuals can obtain a designated parking space for themselves as a reasonable accommodation. And then finally, of course, allowance of service animals in a no pet community. And so I put some real life examples up here. This is not the actual animal that we dealt with, but that large pig that you see in that top photo actually had a situation where a woman had two of those in her home. And she treated them like pets, and she had a letter from her doctor saying that she needed them, and she'd had some particular traumatic losses in her life, and these pigs brought her comfort that nothing else so far had been able to achieve, and so she needed them. So what I will say is, for those of you who are thinking, how could this possibly be? I don't want to live next door to a farm. We can put some restrictions on these owners so that their emotional support animal isn't a nuisance to the rest of the community. So, for example, with the pigs, she had to promise and assure the community that she was going to clean up after them so that there weren't terrible smells coming from her backyard. Same with the horse that Kathy and I had. And it's less of an issue with maybe a small dog or a show chicken who really isn't very loud. But when you start having large animals in small spaces, I think that's really where we see a lot of these problems occur. And I will say that the HUD document does go in and say, now, if it's a normal type of an animal that you would have in a home, dog, cat, etc., it's a lot easier for them to prove it's reasonable. If it is truly livestock, particularly when you are in a multi-family setting like attached townhomes or condominiums, they bear a larger burden to prove that reasonableness. The horse we talked about, the pigs we talked about, those were both single family homes where they had at least fenced in backyards. So there's a difference there. And just briefly to touch on the risks. So some people say, well, what if we don't? What if we say no? What if we just don't want dogs in our condominium? The risk to the community, if they are being unreasonable and refusing to allow these emotional support animals, is that there can be a fine. there can be a legal fee. And remember that the aggrieved owner who was denied the emotional support animal has the benefit of a free attorney. So the association pays their attorney to defend. The aggrieved person gets a free attorney per the government, and then the government or the jury, depending on which way the hearing would go, would be able to award a fine and attorney's fees against the association. Even though that person wasn't paying their attorney's fees, there'd still be a value attributed to the government attorney. So we will move on to people. And this is one of my favorite topics, which is gambling. And I did a seminar on this for our local CAI chapter. And this came across my desk because, as you might imagine, everything is, I feel like anyway, everything is fine until it's not, right? So what that means is things are humming along just great in your community until someone raises a flag. And I have a very large community, about 1,000 lots, and somebody raised a flag to my board and said, well, I heard that there was a bridge game going in the clubhouse on Tuesday evenings, and you need to know that that's illegal. And so the board thought, there's no way that's illegal. These ladies are playing for pennies. That can't be. And so I looked into it for them and pulled the statute, and by and large, she was right. So it is illegal because, and this is in North Carolina only, because this is the North Carolina statute. Any game of chance or any person who plays or bets on any game of chance at which any money, property, or thing of value is bet, and that's the key, betting, shall be guilty of a Class 2 misdemeanor. Now, that doesn't mean that the police are going to raid your clubhouse and take everybody away in handcuffs, but what it does mean is that boards really should not turn a blind eye to things that they know are not compliant with the law, right? So it's one thing if groups want to get together in each other's homes, but to sanction something at the clubhouse or to allow something to happen at the clubhouse that is not in compliance with the law, we should be careful about that. Now, South Carolina, our friends to the south, actually allow certain games. So they call these games social games. And we kind of think about this as tile games, card games, and dice games. I think about Mahjong, you know, maybe even poker, bridge, those types of games. It specifically talks about community clubhouses, and this statute specifically says it's fine if you play those games. But again, the kicker there at the bottom is so long as there is no betting, wagering, or gambling of any kind. So as long as you're keeping it friendly, I know if you, some people just play for empty chips that don't have a monetary value, that would be fine. I think it's just the value ascribed to things that turns it in South Carolina. So enjoy your fun in your clubhouse, but try to stay in compliance with the laws.
So, Ellen, what about a group of people go to the clubhouse? They are going to play Bunco, and everybody brings $3. Part of that goes to paying the cost of the refreshments, and then the rest of it is given to some winners. Is that considered betting?
So again, I mean, I think it's probably betting. I mean, probably, right? So I'm not aware of ever having heard of or seeing anybody at the courthouse who's there to pay a fine because they won $10 at Bunco, right?
Yeah, that's right. Yes.
I don't want to strike too much fear in all of you, but what I do want to say, just kind of the overarching message is we just need to be mindful of the activities that we're allowing in the clubhouse, right? So I think you're probably fine. Again, you know, unless somebody says something and creates a problem, just like most things in life. It's fine until it's not. But I think if you, in North Carolina, if you read this statute strictly, it's a game of chance and there's some monetary wager there. Now, it's very small, but I think strictly construed, it probably counts as gambling because you lost the money or you won the money. There was no in between.
Thank you. And I would like to mention to everyone, if you have a question, you can use the Q&A function of this webinar. The chat function doesn't work, but the Q&A does. So we do have a couple of comments. One is in North Carolina. What if there's an entry fee for a tournament and the winner gets the money, say $1 a person for 12 people, and somebody wins $12? That again looks like our Bunco example of $10, right?
I think it is, yes. And let me see if I can go back. So here's the North Carolina statute again. And it says any person that operates a game of chance or any person who plays at or bets on any game of chance at which money, property, or thing of value is bet shall be guilty. And so to me, it is just that act of here's my money. You turn your money in, you play your game, and you either walk away with your money or you lose it all, or you walk away with more than you came with. I think that's the part where the game of chance comes in.
Okay. And we do have more questions. As we know, this is kind of a topic that usually generates a lot of interest, right? Another question is, what if a board finds out after the fact that the renter of a clubhouse does the act of gambling? What resource do we have on that owner?
So I would say this. I mean, if it's a first offense, if you found out after the fact, if it was something like this, a game of Bunco, or if the person
Bingo.
who hosted it, right, in other words, wasn't profiting from the game, if they are not a bookie, in other words, if they're just there hosting a party and it's, as Kathy suggested, $1 goes to refreshments, $1 goes into the kitty, that kind of thing, then my recommendation is to educate them and say, we've heard about this. I'm sorry. You may not be aware, because they probably aren't, that this isn't able to happen here at the clubhouse. And you're not going to be able to host that again. I don't think you need to go so far as to fine them or to strip the winner of their winnings. But I do think that we just need to be mindful that we don't want to encourage and promote things that we know are contrary to law.
And in my viewpoint, if the association sponsors it, it's one thing, but a homeowner doing it isn't quite the offense as if the association hosted. Is that correct?
Sure. I mean, you do have different layers of liability. So, and again, it seems the law in North Carolina suggests that it's a misdemeanor for the person that essentially hosted. So what's interesting is in the event of an association, association is all its members. So there would have to be somebody to blame for hosting this event. But, we're not in the business of trying to get out of things that go wrong. We're in the business of trying to prevent things that go wrong, right? So we're trying to give the best advice we can and say, steer clear of it if possible. If it's already happened, educate it and encourage that it doesn't happen again.
Okay. So some other questions are schools doing a 50-50 night that would fall under the same. Yeah.
So that I will say is totally different. And I will also say that the law, at least in North Carolina, allows 50-50 raffles for any entity that is a nonprofit corporation. So the vast majority of our associations in North Carolina are registered nonprofit corporations. They're not 501c3s, but they still are nonprofits. And the law allows you to have two non, no, two 50/50 raffles per year, and you can use those to raise money for your association. So I think that's a great option for a fundraiser. Obviously, schools do them, sports organizations do them, and it is allowed and it's legal, as is, of course, the North Carolina State Lottery. Now, sports gambling is legal in North Carolina, not yet in South Carolina, but it is in North Carolina. So things are changing slowly, I think. I don't know that betting, like table games, will ever be legal, but you can do 50/50 raffles if you're a nonprofit.
Thank you. And
You're
someone
welcome.
wanted to go back to support animals, if that's okay.
Yes, sure.
What about if the health department states no animals in the pool? Could someone still bring their emotional support animal in the pool?
So I have dealt with that issue before, and I've dealt with it with HUD, and I've kind of made that argument as well that, hey, the health department says they'll shut us down if people bring their kangaroos or dogs or whatever's flying around the pool in the pool, and they're not supposed to be within so many feet of the pool. And so I have had in my litigation with HUD some good warm reception to that issue. I really believe it probably depends on whether that animal is an emotional support animal or whether it is a true service animal.
Mm.
And, you know, I've had this happen in the gym facilities, like health club type facility, part of common areas as well. If somebody has a dog that's supposed to tell them when they're about to have a seizure, for example, you know, you want them to be able to have that dog with them, right? If, especially if they're on a treadmill or in or near like exercising or swimming, you know, or anything. So I think that there are ways to very gently deal with that issue. But I have had success with emotional support animals and having HUD agree that they do not have to be, or they can be prevented from entering the pool pool area, excuse me.
Thank you. And then who has the burden of showing there is a disability? Could you explain a little bit about that?
Sure. The owner with the disability has the burden of showing there is a disability, but that burden, I will share, is not very high. So they don't have to produce their actual medical records. All they have to do is send in a letter from either it's a healthcare provider. So it doesn't even have to be a medical doctor. I've seen them from therapists, from not for like, for example, not psychiatrists, but just a therapist. A counselor has been accepted before with HUD. It can be a doctor. And so that's where I think things get a little gray and touchy, particularly if people are a little skeptical of a particular owner. Like for example, they've had the dog for a long time. The rules change. Now, all of a sudden, the dog becomes an emotional support animal type of a situation. But what the law says is we can't go too deep. And unless we have reason to believe that the information presented is fraudulent or something else, then really we have to accept on its face a letter from a medical provider.
Thank you. And it isn't a government entity that issues the certifications. It's usually medical personnel or a counselor.
Correct. Now, again, there's a difference between a service animal and emotional support animal. So a service animal does have to show specific training to provide the service that it is claimed to be providing. Emotional support animals do not have to have any training. And so there is nobody issuing any type of a certification for an emotional support animal. Now, some of them may have certificates, but there is no certification required. And so all that is required for emotional support animal is a letter or documentation from a medical provider that says the person has a disability And based on that disability, they don't have to say what it is, just a disability. And based on that disability, are in need of an emotional support animal.
Okay, thank you.
You're welcome. All right, so we will go to political canvassing. I got 3 calls in a week on this a couple weeks ago, and it's been an interesting topic. So the calls were, Ellen, people are in the neighborhood knocking on doors and making residents uncomfortable, and we have a no soliciting sign at the front of the neighborhood. What do we do? And then I had another call that said that a board member's spouse sent a peremptory email to the manager and said, just so you're aware, next week I'm planning to canvass the neighborhood, and I'm allowed to do this per the attached federal statute and this website about canvassing in the First Amendment. And Ellen, what do we do? So the answers to those questions were different. Those 2 different questions posed to me had 2 different answers. And so we'll dig a little bit into why. But in general, what is political canvassing? It is essentially, like shown in this photograph, when people walk around, most of the time they actually physically knock on your door, and they provide you either a pamphlet or just give you a little prepared elevator type speech about why you should consider voting for their candidate, the candidate they would like for you to vote for. Sometimes they want to engage you in a debate, particularly if they see another candidate's sign in your yard, but they want to have that discussion, and their whole purpose is to try to persuade you to consider voting for their candidate. So the first question, is it solicitation? If you have a no soliciting sign on your door or at the front of the neighborhood, is somebody who is canvassing violating that sign? And the answer is usually not. And the reason is, usually, if we're going with a strict what is political canvassing, they are not asking for money. They're just asking for your vote. And a vote is non-commercial. So they are not soliciting, and the no soliciting sign doesn't help you with this particular issue. So then let's go to, is it trespassing, which was what I told my first caller. My first caller who said there are people in the neighborhood. And I said, well, don't you have private streets? And she said, yes, we do. And I said, well, tell them to get off your property if you don't want them there. And she said, no, we definitely don't want them there. We've had 5 owners call us already. They're very upset. There's some older people that live here. Dogs barking. They don't like people at the door. So the manager ultimately told them, I'm sorry, this is a private community, private roads. You need to leave. And they even called the sheriff's department, and the sheriff's department told them to leave because they refused initially to do so. So that really is the way to deal with the issue if you feel it's a problem. Some people say it's their First Amendment right, I'm not going to force it. I will tell you this, that if somebody is in your personal yard and you don't want them there, regardless of whether they're soliciting or canvassing, if you tell them to leave, I don't want you on my property, they are supposed to respect that. And if they don't, then technically they are trespassing. So you can call whoever you need to call to solve that problem. Don't call your manager though. Call law enforcement if you feel like somebody really is trespassing. So if there is a no trespassing sign on your personal property or on the common area and people are canvassing there, I do believe they are in violation of that sign regarding trespass. So I hope that was helpful. And the next topic about property is disaster recovery. As everybody is aware, we've had some tremendous and tragic situations occurring in the last month in North and South Carolina, from no-name storms and then a hurricane. And so we've had a lot of roads washed out. I've had a few communities, unfortunately, where buildings have been condemned, condominiums and the like. And so we are getting questions about, in particular, what should we do when it comes to continuing to collect assessments? If a building is condemned, either because of a hurricane or, I've had situations where buildings just are condemned because, again, we're out here on the coast and structural steel corrodes and the building is not safe and therefore it's condemned, or there's a fire and it burns so badly that it's condemned. Can we or should we continue to collect assessments? And so the answer, even though it is a difficult time for our owners, is yes, we should continue to collect assessments because there are still ongoing expenses that are being incurred, even if the building or buildings are condemned and can't be lived in. And those things include insurance, management fees, landscaping. If it's debris removal, that's going to actually increase probably rather than decrease. With respect to management fees, you might be experiencing more because your manager is having to deal with insurance claims, for example. You still have liability insurance. You still have to, fence off the property. Sometimes you have to provide security, just depending on the specific situation. But I guess my point is the expenses don't go away. Sometimes they change. Sometimes they actually increase. It just depends. Now, if, and this is very rare, but I have seen situations where if there are, for example, 10 buildings in a community and one of them is condemned and each building pays its own cable bill, and each building pays its own electrical bill or water bill, and there's nobody there to use the cable or to use the water or to use the electricity, and the building has been totally burned to the ground and it's not going to be built anytime soon, then I think in that situation, if it is very specifically separate, and if the board is inclined to do so, then you could just adjust those portions of the assessments. Now, again, that's very rare. And, so that needs to be done very intentionally with a lot of thought. And I would say consult with your attorney because you do want to make sure that you're being fair, that you're applying the covenants correctly, and that, you are not trying to help one owner while punishing another at the same time. And then one thing, though, I think you could do, which I think would be good if it's your community's ability to do so, meaning you're in an okay financial state, is to suspend late fees or suspend foreclosures just because, those people may not be able to, for example, if it's a rental community and they're not able to rent their unit, therefore they're not able to pay as much as they would have. Being understanding in that regard, again, to the extent you can be. You could always continue to file a claim of lien if you felt you needed to do that, just to protect your priority on that particular lot or unit. But you could forego the late fees or other interest fees that you might otherwise be inclined to pursue if everything was normal within your community. That was all the slides that I had prepared. Again, I'm more than happy to answer any questions that you have about these topics. Some of them are more sensational than others, I'll admit, but animals, people, property, etc.
So the questions that we haven't answered yet, a lot of them go back to the gambling. We have one with, does an NCAA tournament pool circulating in the neighborhood violate the North Carolina prohibition on gambling?
So in North Carolina, I did read some about South Carolina because I don't practice in South Carolina, I'll confess. And so I had to educate myself a little bit about their gambling laws. And it specifically said that like fantasy football was not okay in South Carolina, which was kind of surprising to me. But in North Carolina, now that we have sports betting, I would venture to say that some of that has probably changed. And I'm not going to profess to be an expert on sports betting. So I can't really comment specifically and cite you to a statute about it. But I guess the purpose of me attacking or addressing these gambling issues was really about doing it at the clubhouse or using the clubhouse or the community facilities as the landing ground for that. So if it's a situation that's not association sponsored, that just happens to be going on in your association, I think this is kind of a good segue in general to say, um, just because something is happening within the four corners of your association doesn't necessarily mean the association and you as the board are responsible for monitoring it, policing it, governing it, objecting to it, even. And so I think that's an important message. But if, for example, somebody's got an NCAA pool or they're doing Super Bowl squares or whatever they're doing just for fun in your neighborhood, then I don't believe it's really an association or board concern. Now, if the association is doing it, I think, maybe consider not doing it. But if it's just happening in the neighborhood, then I think it's totally fine. And that's kind of the message I gave people when they wanted to play Mahjong and bridge is if you do it in someone's living room, right, and it's not association sponsored, then that's a private situation between whoever's there.
That
I
is a
don't think the
great,
board,
yeah, that
yeah,
is a great way to separate that. Is it something the association needs to go looking for? Not really. But if it's happening in the clubhouse or association sponsored, you might want to take another look at it, right?
right, exactly. Exactly.
So, one said is can cash prizes be given at trivia and bingo nights when homeowners buy tickets to attend? I think we answered that.
And
Raffle
I will
exposure.
say, there is a lot of regulation on bingo in particular. And I covered this at my seminar. I don't know why, but bingo is the most complicated statute, I'll venture to say, one of the most complicated statutes in the book of statutes for North Carolina. There are pages of what you need to do in order to register a bingo game. And you can certainly do it, but I can tell you it is probably not worth your time and money because you have to pay to get a permit or a license to hold a bingo game. That it's probably not worth what you're going to have to do. You have to keep certified books. You have to turn those in, ledgers about how much things cost, how much the prizes cost. Yes, you can do prizes so long as they are under a certain dollar threshold. The dollar threshold's really high, so that's usually not the problem. It's really the bookkeeping and the applying for the permit that is the problem. And it's a very extensive application. So my
Yeah, that's
recommendation
amazing.
is,
Yeah.
yeah, it's insane. My recommendation is if you're looking for a fundraiser in that type of arena of kind of a gambling type of a fundraiser, I say 50-50 raffle is the way to go. And in the age of social media where you can create, shareable things and live links, and we just did one for one of my children's sports teams. You actually click on the link, and in real time, you could see what the pot was. And of course, as the pot grows, it's more exciting and enticing to buy that ticket, right? So once you kind of get the snowball effect of, oh, well, I don't really want to buy a $10 ticket if I'm just going to win $100. But if you could win $1,500 for a $10 ticket, now that sounds like a great deal, right? So, and it could be a great fundraiser, and it could be used for general reserves or special projects, whatever the board wants to do with that money. New flowers at the entryway, new pool furniture, whatever your key project is for that season, you can certainly use it to do that. And the reporting requirements are not nearly as strict.
Right. So everybody hear that? 50/50 is the way to go.
That's the way to go.
So back to
That's right.
ADA.
Yes.
An owner says if we rent out one of our 4 community amenities, for example, the swimming pool, does that mean that all 4 amenities must be ADA compliant?
I think it probably depends on whether you cross over them to get to the pool. So, for example, if the pool entrance is in the clubhouse or you go through the clubhouse to get to the pool, then you need to make sure the entry to the clubhouse is ADA compliant. If there is a way to get to the pool that is ADA compliant and separate and apart from your clubhouse, then that's fine. But typically, I know with a pool, you need to have accessible bathrooms, right? Restrooms kind of with the pool. So those would have to be ADA compliant. So it really, I think, depends on how attached your facilities are. If you, though, have a pool at one clubhouse and no pool at the other, and you just rent out the pool at the one clubhouse, I think only those amenities would need to be ADA compliant, not every common element in your whole neighborhood.
Thank you. Thank you. So we have one of our employees dealing with something interesting. They have a homeowner harassing homeowners and the board president with racial slurs as they drive through the neighborhood. Let me get to the rest of that question here. As they drive through the neighborhood or in their own yards, is this an FHA violation? So a homeowner harassing homeowners and the president with racial slurs as they drive through the neighborhood or in their own yards.
It could be, I guess. I mean, I think it really depends. To me, it sounds more like maybe a restraining order type of a thing or a cease and desist type of an issue. These issues are understandably very difficult, emotionally charged, and difficult to figure out how to deal with and how to get the best relief possible. Owners who are harassing others, whether it be the board members, managers, or other owners, I will say that the board is charged with trying to protect its other owners. So if, for example, and I had this situation come up, the harassment is happening at the common area, like for example, by the pool. If this owner were to be at the pool and saying these things to others who are at the pool, then we would be tasked with trying to step in and resolve the issue. If they are driving around the neighborhood and just shouting things out of their car window, it becomes a little bit different, in my opinion. You still want to try to address the issue, but it's not necessarily you have to address the issue in any certain way. So I do want to say that. So there is some liability, in other words, for the board if things happen on the common area under the FHA. I don't know that there's that same liability if somebody just happens to be driving past. But I do think that, reaching out to this owner, trying to figure out what the problem is, if they can be reasoned with, maybe that's a community mediation through CAI. Maybe that's, calling them in to talk to the board, giving them a special audience with the board to talk to them that way. Trying to figure out what is at the heart of this situation. Maybe they got an ARC denial they didn't like. Maybe there's something else happening there that we might be able to deal with. And if not, Unfortunately, I'll be in court in 2 weeks on 50C hearings, and we don't like those. But what those are restraining orders that we can ask the court to enter if we have a situation where it escalates to the point where people don't feel safe.
Mhm.
And that is definitely a last resort, and unfortunately, not something we want to deal with, because we want everybody to feel safe. But if that is happening, then that direction might need to be pursued as well.
Does that go through the compliance process? Is that a violation of any of the covenants, perhaps? I know the first thing is contact your attorney, right? Because that's an
Yeah.
unusual and a serious situation.
Yes. It's hard to say whether it violates the covenants. I think it's probably, if it's happening at the pool, for example, it's easier to say it might and likely does violate a rule about behavior at the pool. Particular if alcohol is involved or something of that nature. If it is just somebody who's mean-spirited and saying ugly things in the neighborhood, not necessarily on a common area, it's a lot more difficult to pigeonhole that into a covenant violation. Particularly, I will say, because the Court of Appeals, at least in North Carolina, has recently said that the nuisance provision that we've all loved for so many years
Yeah.
is often not worth the paper it's printed on, because it's not very specific. So I doubt there's anything specific enough that we could use to fine an owner in that situation, which is why I think, that sitting them down and trying to figure out what the problem is might be the best way to actually curb the behavior.
Thank you. So another question we have is, if a disabled homeowner wants a special chair to be set up at the pool to be able to get in, does the HOA have to install and pay for it?
Great question. So I think you're referring to the motorized chairs that lower people into the pool.
I would think so, yeah.
Yes. And so what the law there says is that the owner actually would have to pay for the installation, but once it's installed, the HOA would pay to maintain it. So what gets a little questionable here is, oftentimes what I see is, because the HOA expects this to be used by more than one person over time, that the HOA typically either pays for it, or pays for part of it, or upgrades it to one they think will last longer or maybe has a better warranty, not because they have to, but because they recognize that with those ongoing maintenance responsibilities, that they would like to have a piece of equipment that has better longevity.
That makes perfect sense. We have a question. Will there be seminars regarding what situations could open individual board members up to a lawsuit? We can certainly do a separate seminar on that, but can you think of just a couple of situations where a homeowner individually might be liable?
So typically, and I will say that there are some really good laws to protect you as board members. And as long as you as board members are acting in good faith and in the best interest, you're using your business judgment, it is actually called the business judgment rule, then that is a legal defense to your liability. So first and foremost, know that, have some assurance that you are not out there on an island by yourselves waiting to be attacked or sued. That's not the case. Second thing is, you will have directors and officers insurance that will provide you a defense in the unfortunate situation that you are sued. Now, the things that can open somebody up to individual liability and true individual liability are acting ultra vires, which means without any regard to the corporation itself, to the association, stealing money, doing things that are knowingly fraudulent, hiding things, destroying evidence in a case, things like that. So I don't expect that those arise very often at all. I think most of us are out there just doing the best we can, particularly board members. And so when you're relying on the opinions of your advisors, be those accountants, lawyers, managers, each other, you're doing the best you can with the information that you have, that there is not going to be that true individual liability in those situations.
Thank you. So that good old business judgment rule, we hear a lot about that.
Mm-hmm.
Well, that takes care of all the questions that we had asked. You answered them, so we certainly appreciate that. And Ellen, you're just such a wonderful resource, and we certainly appreciate all you do for our profession and for our clients. We appreciate your time today, and we look forward to seeing you again before long. So thank you, everyone, for joining us, and we will see you again next month. And again, this will be posted on the CAMS website for you to review at your leisure. Thank you
Thank
very
you.
much.